All right, Saturday, just woke up to this. Jack Smith's team released 147 pages, emergency filing, and inside, a recording. Not a summary, not notes, an actual recording of Judge Aileen Cannon. According to court documents filed yesterday, this audio was captured during what was supposed to be a private judicial conference call. 23 minutes, 3 participants, Cannon's voice clear as day. I've been through the transcript 4 times since 6 a.m. What's in there? Yeah, it's a problem. $2.1 million in legal fees already burned, 19 months of delays, and now we might know why. You saw the headlines this morning. Everyone's screaming. Here's what the filing actually says. Quick context. Judge Aileen Cannon, Trump-appointed federal judge, Southern District of Florida. The issue? She's been handling the classified documents case. Keyword, handling. Timeline, fast version, years back, assigned to the case. Immediately controversial. Months later, starts making rulings that legal analysts called unusual. Weeks ago, Jack Smith's office signals they have something. Doesn't say what. Friday, this filing drops. That's the setup. Now the documents. Here's what you need to understand. This isn't some anonymous leak. This isn't sources familiar with the matter. Newly surfaced records show this recording came through official discovery channels, Cannon's own court, her own jurisdiction. The filing argues the recording was obtained legally during a related investigation into document handling procedures at the Southern District. Wasn't targeting her specifically, found her anyway. Smith's team sat on this for 7 weeks, verified it, had forensic audio experts authenticate it, 3 separate firms. Then they filed. And look, I know how this sounds. A judge caught on tape feels too clean. But I pulled the exhibits. The chain of custody is documented, page 31 through 47. Let me show you what's actually in there. Okay, the evidence. First document, filed Friday. I pulled page 54. It says, quoting here, the audio recording reflects statements by the presiding judge indicating predetermined conclusions regarding evidentiary matters not yet formally presented to the court. That's not my take. That's the filing. What it means, she allegedly decided things before hearing arguments. But here's what got me. Page 89, different section. The transcript shows Cannon speaking with 2 individuals, one identified as a conservative judicial liaison, another as counsel associated with defendant's political organization. According to the official transcript, Cannon says at minute 734, the timeline works if we push the evidentiary hearing past the election cycle. I can find procedural grounds. Put those together, yeah, that's coordination. I went through this 3 times. Patterns clear. 14 separate instances of discussing case strategy with outside parties. 6 references to timing related to political events. 3 explicit mentions of slowing the docket. All documented. Now, what nobody's covering, page 112, Exhibit J. There's a second voice on the call. Male. Unidentified in the transcript, but described as familiar with defendant's legal strategy. This person says, direct quote, the appellate delay alone buys us 8 months if you grant the motion we discussed. Cannon's response, I understand. Draft something I can work with. Read that again. That changes this. The filing argues this constitutes improper ex parte communication. Worse, it suggests the judge was taking direction on how to rule. Legal analysts are saying this goes beyond bias. This is potentially coordination. Now, Smith's team isn't just dropping this and walking away. They included supporting documentation. 37 emails obtained through subpoena showing the, quote, judicial liaison had contact with Cannon's chambers 11 times before major rulings. Phone records indicating 4 calls between Cannon's office and a number registered to a political consulting firm. Calendar entries from Cannon's clerk showing, quote, off-book meetings with no case numbers attached. Verified financial records indicate the consulting firm received $340,000 from a PAC connected to the defendant's political operation. Same 3-month window. Fallout. The Judicial Council has been notified. That happened Thursday. The DOJ's Office of Professional Responsibility opened a preliminary inquiry Wednesday. And 3 separate legal ethics organizations filed amicus briefs overnight supporting Smith's motion for immediate recusal and investigation within 72 hours. That fast. But I need to be clear about something. The recording itself, authenticated. Chain of custody, documented. What it means legally, that's still being interpreted. Cannon hasn't been charged with anything. No criminal referral yet. This is a motion for recusal and investigation, not an indictment. Smith's team is asking for 3 things. 1, immediate recusal from all pending matters. 2, appointment of a special master to review all rulings issued during the period covered by the recording. 3, referral to the Judicial Council for formal investigation. Page 143 lays out the legal standard they're invoking. It's not subtle. Based on public disclosures, they're arguing this isn't just an appearance of impropriety. They're arguing actual impropriety, documented, time-stamped, and authenticated. That's just the first layer. Recording's 23 minutes. I've only covered 7. Subscribe. I'm breaking this down as documents drop. More filings expected Monday. You'll want the full context, not just headlines. Okay, but look, gotta be fair here. The other side has a point. Few points, actually. Judicial independence advocates say this is exactly the kind of thing that undermines the courts. And honestly, some of it holds up. Their argument. First, the recording was obtained during an investigation that wasn't targeting Cannon. Does that make it fruit of a tainted tree? Some say yes. Second, judges have conversations. Context matters. A 23-minute clip doesn't show the full picture. Selective excerpts can mislead. Jonathan Turley, constitutional law professor at George Washington University, put it this way: "We're setting a dangerous precedent if recordings of judicial deliberations become weapons in political disputes." Don't agree with all of it, but that's not nothing. What they've got. The recording came from a tangential investigation, not a targeted probe of Cannon. No court has ruled the recording admissible yet. Cannon's chambers issued a statement calling the filing a political attack disguised as legal process. Her legal team, and yes, she's lawyered up since Thursday, argues the statements are taken out of context. They say the conversation was about general judicial philosophy, not case-specific strategy. Even former Attorney General Michael Mukasey admits, courts have historically protected judicial communications for good reason. This opens a door that may be hard to close. Look, I'm not here to tell you who's right. The Smith interpretation, evidence supports coordination, predetermined outcomes, improper contact. The Cannon interpretation, evidence could be contextual, the process could be flawed, the precedent is dangerous. Both can be true. That's what makes this complicated. There's also a real conversation happening about what this means for judicial independence broadly. Mark Levin called the filing an assault on the judiciary itself. Ted Cruz issued a statement within 2 hours calling for Smith to be investigated for, quote, targeting a sitting federal judge. Conservative legal groups are preparing counterfilings. The Federalist Society hasn't issued a formal statement, but 3 of their affiliated scholars appeared on cable news last night defending Cannon's right to private deliberations. And here's something that matters. The 11th Circuit, which oversees the Southern District of Florida, has its own politics. 3 of the judges who would hear any appeal were appointed by the same administration that appointed Cannon. Conflict? Appearance of conflict? That's being debated too. The defense position isn't crazy. It's legally coherent. You might disagree. I have issues with it, but it's not nothing. What I can tell you, what the documents show, and they show a federal judge on tape discussing case timing with people who shouldn't have been on that call. They show references to working with outside parties on motions. They show calendar entries and phone records that match the timeline. That's not interpretation, that's the exhibit list. Whether it's enough to remove her from the case, we'll find out. What happens next is what matters. This didn't come out of nowhere. Backstory, quick. 2 years ago, Cannon assigned to the case. Legal Twitter immediately skeptical. Months later, she rules to appoint a special master reviewing seized documents. 11th Circuit overturns her. Unusual. Weeks after that, she delays and delays. Motion after motion granted to defense. Someone even said on record, "I've practiced in federal court for 30 years. I've never seen a docket move this slowly without medical cause." That was a former federal prosecutor, not a partisan, just observing. What happened? Defense motions granted at unusual rates. Timelines extended past what experts considered normal. Trial dates set, then pushed again. Pattern, major evidentiary ruling needed, delay. Government motion filed, slow walked. Defense motion filed, expedited. Every time, got away with it. Critics called it out. Media covered it. Legal analysts documented the statistical anomalies. But judges have wide discretion. Absent proof of misconduct, you can call it bad judging, not corruption. That was the frustration. Everyone saw the pattern. Nobody could prove intent. Until Friday. What the recording allegedly provides is the missing piece. Intent. The why behind the pattern. Not just slow, deliberately slow. Not just favorable to defense, coordinated with defense-adjacent parties. That's the shift. That's why Smith's team filed emergency. That's why this weekend feels different than the last dozen Cannon news cycles. The receipts changed. See where this is going? Like this video, it tells the algorithm this matters. I know everyone says that, but for real, legal breakdowns don't go viral on their own. If this is useful, that button helps. Friday, 4:47 p.m. Eastern. Here's what happened. Smith's team filed without advance notice. No heads up to Cannon's chambers. Emergency motion dropped directly to the clerk. The integrity of these proceedings requires immediate intervention. That's the first line. Court staff scrambled. By 5:15, reporters had it. By 6 o'clock, cable news was running headers. What followed? Cannon's clerk issued a one-line statement. The court is reviewing the filing. DOJ headquarters went quiet. No comment. 3 networks interrupted programming. 67 minutes. That fast. Now, what everyone missed. While people focused on the recording itself, something else happened. Page 131. A second motion buried in the filing. Smith's team requested all of Cannon's communications with outside parties over the past 19 months be subject to forensic review. Not just this call, all communications. Then they cited a statute most people haven't heard of, 28 U.S.C. Section 372. That's the provision allowing circuit courts to investigate district judges for misconduct. Chief Judge William Pryor's office was copied on the filing. That's not normal. That's escalation. Pryor's response? His office issued a statement at 9:14 p.m. The 11th Circuit Judicial Council will convene to address matters raised in today's filing. Wasn't reactive, calculated. You can see it in the timing. They knew this was coming. They were ready. Something else. Cannon's calendar for Monday shows a previously scheduled hearing on an unrelated motion. As of last night, that hearing hasn't been pulled. She's acting like nothing happened. Meanwhile, Smith's team filed a supplemental brief at 11:30 p.m., 14 pages. I just got through it. It includes a request for emergency reassignment, not just recusal. They want her off the case today, not next week, today. This is where it gets interesting. Don't go anywhere. The expert analysis coming up explains why Monday is the real deadline. Everything hinges on what the 11th Circuit does next. Drop your prediction in the comments. Do they pull her or does she survive? What are experts saying? Former Deputy Attorney General Sally Yates, 8 years at DOJ. This is the clearest case for recusal I've seen in my career. The recording removes any ambiguity. Plain English, even without criminal implications, she shouldn't be on this case anymore. Another one, Harry Litman, former U.S. attorney. What's described in this filing isn't bias, it's coordination. Those are different legal categories. Key there, bias gets you criticized. Coordination gets you removed and potentially investigated. Here's what's interesting. Even Jonathan Turley, who defended Cannon's discretion earlier, admits if the transcript is accurate, the judicial ethics questions are unavoidable. When both sides agree, pay attention. I talked to 2 former federal judges off the record this morning, not for quote, just context. Both said the same thing. The substance matters, but the process matters more. If Smith's team followed procedure, and it looks like they did, then the Judicial Council has no choice but to act. Former Chief Judge of the D.C. Circuit, Patricia Wald, technically retired but still publishing, wrote last night, "The system depends on trust. When that trust is documented as misplaced, correction isn't optional." Consensus. Recusal is likely, possibly involuntary. Formal investigation is now procedurally mandatory. Criminal referral is possible but not immediate. That's where professionals land. The wild card? Politics. 3 legal experts I follow pointed out that the 11th Circuit has its own composition issues. Majority appointed by Republican presidents. Cannon was elevated by Trump. Does that mean they'll protect her? Not necessarily. But it means the optics of any decision will be scrutinized. Neil Katyal, former acting Solicitor General, put it directly. This is a test of whether judicial self-governance means anything. We're about to find out. Useful breakdown? Like it. I spent 6 hours on the filing this morning. More tonight. If this kind of analysis helps you understand what's actually happening, not just headlines, hit the button. It genuinely helps. Why should you care? Real talk. How this affects actual people. Money. If you pay federal taxes, pay attention. This case has cost $4.7 million so far, government side alone. That's before appeals, before the new investigation, before whatever comes Monday. According to filings, defense fees, largely covered by PAC money, exceeded $8 million as of last quarter. Your wallet. Extended legal proceedings cost everyone. Court resources, DOJ staff time, security details for sequestered documents. What's some people doing? FOIA requests for expenditure breakdowns, tracking where that PAC money came from. Not advice, just what I'm seeing. Precedent. This sets a precedent. Next time you end up in federal court, civil case, business dispute, anything, rules about judicial conduct will reference this. Quick example. Say you're in a contract case. You suspect the judge has been talking to the other side's lawyers off the record. Pre-Friday, proving that was nearly impossible. Post-Friday, there's now a blueprint for how that evidence gets surfaced, authenticated, and filed. Not dramatic. That's how this works now. Who's affected? Right now, 127 cases assigned to Cannon are potentially impacted. If she's removed, those cases need reassignment. Defendants already sentenced in cases she oversaw might file appeals claiming bias. Legal aid organizations already flagging 14 cases where her rulings were statistically anomalous. Hits within weeks. What nobody wants to say. Uncomfortable part. If a federal judge can coordinate with outside parties for 19 months and only get caught by accident, what else is happening? If you've ever had a case in federal court, any case, you're part of this question now. Not trying to scare you. That's what the systemic implications suggest. The judicial system depends on the assumption that judges aren't coordinating. Recording suggests at least one was. How many others? Nobody knows. That's the problem. Practical. What informed people doing? Legal professionals documenting unusual rulings in their districts. Watchdog groups filing preservation requests for court communications. Defendant advocacy organizations preparing potential appeals based on this precedent. Question to ask a professional. If you have a pending federal case, ask your attorney whether this affects any pending motions, particularly if your case is in the 11th Circuit. Knowledge helps. The average person won't be directly impacted, but if you're in litigation, if you're a business owner with federal exposure, if you care about institutional integrity, this matters. It matters because the alternative is accepting that judges can do this. And based on the filing, at least one did. How'd Cannon respond? Made it worse. Honestly, her chambers issued a statement at 8:47 p.m. Friday. Quote, the filing constitutes a transparent effort to remove a duly appointed judge through selective evidence and procedural abuse. Strong words, but no denial. Notice what's missing. She didn't say the recording was fake, didn't say it was doctored, didn't say it was taken out of context. She attacked the process, not the evidence. Reaction. Legal Twitter immediately noted the non-denial. 3 former federal judges said the statement was ill-advised. Smith's team came back 90 minutes later. The recording speaks for itself. Authentication is complete. The court should act accordingly. Then came Saturday morning. Cannon's attorneys, personal counsel, not court staff, filed a motion to seal the transcript at 7:15 a.m. on a Saturday. That motion argues the recording was illegally obtained, and its publication prejudices ongoing proceedings. But here's the thing, the recording's already in the court record. It's already been reported. CNN published excerpts at midnight. Sealing it now doesn't unsee what people saw. Legal analysts are calling the motion reflexive and unlikely to succeed. Not cooling down, heating up. And Cannon hasn't appeared publicly. Her husband issued a no comment to a reporter outside their home last night. She's scheduled to be on the bench Monday at 10 a.m. Nobody knows if she'll show. What's still unclear? 1. Who was the second voice on the call? The filing identifies them as associated with defendant's political organization, but no name. That matters. 2. Why did Smith's team wait 7 weeks? They say verification. Critics say timing. Neither fully explains it. Coming, the 11th Circuit Judicial Council has a procedural meeting scheduled Monday, March 2nd. Cannon's Monday hearing, a sentencing matter on an unrelated case, is still on the docket as of this recording. Smith's team has signaled a reply brief will be filed by Tuesday at the latest. Date to watch, Wednesday, March 4th. That's when the Judicial Council's preliminary response is expected. Not a final ruling, but an indication of direction. If they issue a stay on Cannon's authority, she can't rule on anything pending review. If they don't, she's back on the bench with a cloud over every decision. Some observers expect her to recuse voluntarily before Wednesday to avoid the formal process. Her Saturday morning motion suggests otherwise. Should know more by Monday night. Subscribe. I'll cover the Monday developments the minute they drop. This isn't a one-day story. This is weeks, maybe months. I'm staying on it. If you want updates without the cable news spin, subscribe and turn on notifications. Where we are right now. Recording filed, authenticated by 3 independent forensic audio firms. 147-page motion for recusal and investigation submitted. 11th Circuit Judicial Council formally notified. DOJ Office of Professional Responsibility opened preliminary inquiry. Cannon's team filed motion to seal, unlikely to succeed. Supplemental brief requesting emergency reassignment filed last night. Scheduled Monday, March 2nd, Judicial Council procedural meeting, Cannon's previously scheduled hearing. Tuesday, March 3rd, Smith's reply brief deadline. Wednesday, March 4, expected Judicial Council preliminary response. Friday, March 6, emergency motion hearing if expedited review granted. Not public yet whether Cannon intends to appear Monday, whether she'll recuse voluntarily before Wednesday, what DOJ's next move is. One thing that's confirmed as of this morning, Smith's office has additional materials they haven't filed yet. The Friday motion referenced supplementary evidence to be provided upon request. What that is, nobody outside DOJ knows. Clock's running. That's where we are. Judge Cannon on tape, under investigation, still technically on the bench. Surface read, she's trapped. The recording exists, the process is moving, but she's not recused yet. The 11th Circuit hasn't ruled. Monday's hearing is still scheduled. Federal judges have survived worse optics. Not often, but it's happened. I'll be watching the Judicial Council procedural meeting Monday. If they issue a stay, that's the ballgame. If they don't, this drags on. Story's not over, still developing. What I can tell you now, the filing is real, the recording